Okay, so we should be able to begin now. Thank you, Vivian and Edward, for again joining tonight's tutorial. We are discussing the week 5 topic on unauthorized decision making. And in terms of the outcomes, after studying this topic, you should be able to discuss and explain whether legal authority is required for every executive decision or action to be made. Discuss and explain unauthorized decision making and the types of executive decisions and actions that do not require specific legal authority. We have 4 legal problems that we will be examining tonight. But before we start discussing the legal problems, are there any questions or issues that you may want to raise? None? Okay. So we could probably begin. Vivian, do you mind reading question 1 for us?
Okay, question 1. Judicial review is said to be of limited scope that focuses on the process of decision-making, observance of fairness, procedural fairness, and natural justice, etc., and not on the decision itself. In what circumstances is judicial review said to involve a review of the decision itself?
Thank you. Would either of you wish to try to answer the question?
Yes, I think, okay, there are common law grounds and statutory grounds for judicial review, like we discussed in week 4.
Mm-hmm.
So for me, some common law grounds are excessive or unlawful exercise of administrative power, like in the case of Attorney General of New South Wales versus Queen, 1990, 170 CLR 1, where there's another ground is when beyond constitutional power for being unconstitutional. So when a decision is taken that is beyond constitutional power, or when it is unconstitutional. In the same case, Attorney General of New South Wales versus Queen, 1990, 170 CLR 1. And when the decision is beyond the power conferred by the statute or by the prerogative of the executive. The same case, Attorney General of New South Wales versus Queen, 1990, 170 CLR 1.
Okay, that's right. Thank you, Vivian. I think the question should have been more specific. And the question really is, in general, we say that when it comes to a review of a factual determination, meaning the merits of a decision, then in that case, it is only administrative tribunals that can review the factual correctness or the merits of an administrative decision. It is not for courts exercising the power of judicial review to examine the factual dimensions of an executive decision. So perhaps the more specific question I'd like to ask is, are there instances when it can be said that the power of judicial review is invoked for the purpose of actually examining almost the factual correctness of a decision, which we said conventionally can only be done by an administrative tribunal, but not by a court exercising the power of judicial review, because judicial review is of limited scope. So the more specific question is, do you suppose that there might be an instance when it can be said that the exercise of judicial power seeks to examine the factual correctness of an executive decision? What do you think?
Is that when the decision itself would be unlawful or unauthorized?
The decision itself would be unlawful or unauthorized. So in that case, it's a question of law. It's a legal question, isn't it? If it's unauthorized, then the question really is it authorized according to law, which is a legal question. If it's unlawful, the question is it according to the law? Again, it is a legal question. The question I'm asking is, would there be an instance when it can be said that a court exercising the power of judicial review is almost seeking to examine the factual basis of an executive decision, which we know is meant to belong solely to administrative tribunals,
yes,
and not the courts?
Okay, is it when there's a breach of the principle of legality, when the decision that has been taken is going against the principle of legality?
Okay, if it's a principle of legality, the basic question is there a law that authorizes the executive action? Which again is a legal question.
The statute, there's a statute behind every executive decision. So if it is, if it has to do with the interpretation of the statute, to see if there's if the executive has acted according to the statute but has gone beyond it, like in the doctrine of ultra vires.
Okay, that to me would still involve a legal question which properly belongs to an application for judicial review, because the nature of an application questioning, raising the issue of ultra vires is whether or not the exercise of an executive power is actually beyond power or ultra vires. Now, there was a statement you made earlier, Vivian, about executive actions always being done according to statute, in relation, for example, to the principle of legality. And that raises the question, is it correct to say that the executive can only act if it is authorized by a statute? In other words, it is authorized by an act of the parliament. So that is the other question I'd like to ask now. Then we go back to the question that I raised. So let me repeat. Is it correct to say that the executive can only act if it has been authorized to act by a statute or by a law passed by the parliament? In other words, it cannot act if it has not been authorized by the parliament. So it needs legislative authorization in order for the executive to act. Is that correct?
Yes.
Okay.
There's one of the judges said that the executive cannot decide. The executive can only take decisions within legislative power.
Okay.
But however, it's not all the time that the executive decision making is restricted by I think they have their prerogative, like in security issues.
Okay.
Yes, they have their prerogative powers.
So would the prerogative power, would the prerogative power be based on a statute? Meaning, is that based on an authorization by the parliament? Or is the executive power a power that belongs to the executive even in the absence of an authorization by the parliament? Meaning, is it a distinct power? Edward, do you have a view on this?
Is this basically asking the same as question 18?
Which one is question 18? Okay.
Yeah, so I've only got my answer in front of me. I don't have the question, but
yeah. So this is actually question 18. Oh, hang on. Okay, but before we go to question 18, let's try to dispense with that question first. Did Vivian disappear? Hopefully she will come back. Why don't we give Vivian a minute, Edward? Because
okay.
It's the two of us now.
Yeah, no problem.
So wait for 7:29 in my clock, which is a few seconds from now. If Vivian doesn't reappear, we'll proceed to okay. So Vivian is back. Thank goodness you're back, Vivian. It was just Edward and me. Okay, are you able to hear us, Vivian?
Yeah, sorry, my laptop crashed. Laptop crashed. Yeah.
I assume that. Okay, so in relation to the first point by Vivian,
yes,
whether or not it is actually necessary for there to be a statutory enactment or an authorization coming from the Parliament before the executive can act, the answer is no, because the executive has certain powers. One is it has power. There is executive power as recognized by Section 61 of the Australian Commonwealth Constitution.
Okay. Yes.
So under Section 61 of the Australian Commonwealth Constitution, the executive has the power in relation to the maintenance and execution of the Commonwealth Constitution, as well as the laws of the Commonwealth Parliament. So Section 61 provides of the Constitution provides the constitutional basis for the executive power. Secondly, there is, as you pointed out, Vivian, earlier, there is the notion of prerogative power. So prerogative powers are powers which have been historically recognized by the common law courts as inhering in the executive, even outside of any legislative authorizations. For example, the power to enter into treaties, the power to enter into diplomatic relations, the power to grant pardons to criminals, and so on. These are, or the power to regulate immigrants or the entry of aliens into Australian territory. These are considered to be prerogative powers belonging to the executive. So even in the absence of any empowering statute coming from the Commonwealth Parliament, the executive has these powers. These are known as executive powers. There can be, of course, the third source would be what is known as the exercise of executive powers on the basis of authorization coming from the executive through primary legislation. So that would be a third source, meaning when the Commonwealth Parliament, for example, vests certain powers on the executive, as it usually does, then in that case, that is the third source of executive power. The fourth source of executive power may be said to, it could be a separate category, or it could be part of Section 61. There are certain implied executive powers, such as the power of the executive to enter into contracts, the power to create its own agencies for the running of the government. You don't need legislative authorization for that. So there are express powers under the Constitution. You can also imply certain powers there. So you also have prerogative powers, and you have powers which are vested in the executive by the Commonwealth Parliament. So having addressed that question, we go back to question 1 now, and that is whether or not there are instances when it can be said that when the judiciary undertakes judicial review, it might be said that it is almost examining the factual basis of an executive decision, which we know traditionally can only be examined in an administrative review or merits review. And the answer to that would be that if we examine the case of the Wednesbury decision, meaning the Associated Provincial Picture Houses Limited versus Wednesbury Corporation, the court in the UK said at the time that when the decision of the executive is so unreasonable that no reasonable authority could ever have come to it, then that decision would be subject to judicial review. And so in other words, it can be said that the judiciary, in undertaking judicial review in that instance, when when there is a decision that reaches the standard of Wednesbury and reasonableness, what has actually happened is that the court in that particular case is almost examining whether there is a factual basis for the decision. So in other words, if on the basis of the evidence, the only decision that can be made is this way, and yet somehow the administrative decision maker makes a decision which is really totally unsupported by the facts, that either meets what is known as Wensbury reasonableness, because no reasonable authority could ever come to that decision, or it can also be said that there is no evidence. So in that case, if you will notice, if you examine the Administrative Decisions Judicial Review Act of 1977 Commonwealth, one of the grounds for judicial review is when there is no evidence, which in a sense is related to an error of law, because any administrative decision that is made has to be based on evidence. So when there is no evidence, that decision becomes unlawful and is a ground for judicial review as well. Okay, before we move on to question 2, any questions? None. So we have Wensbury reasonableness, which can be said to be an instance when the factual circumstances of a decision by an administrative decision maker are being examined, or when it can be said that there is no evidence at all. So it is not the same as saying that the decision is contrary to the evidence. It is really when there is no evidence that will support the decision that, again, will allow the judiciary to almost examine the factual basis of a decision as part of judicial review. Okay, so based on both on common law, following the Wensbury reasonableness doctrine, or following the Administrative Decision Judicial Review Act of 1977, that can be a ground for judicial review. Question 2. Edward, do you mind reading question 2 for us?
The Ministry of Health created a health awareness program that provided a budget of $20 million for a program to promote awareness of men's depression as a health issue. Red Manson asserts that the program is rubbish and has called on the minister to withdraw the funding, claiming that the money is better spent on other programs in the current economic environment. He also asserts that the minister has no legal authority to make the budgetary decision. When the minister refused to revoke his decision, Manson considered filing an application for judicial review on the ground that the decision is unauthorized. He has come to you as a solicitor. What would you advise him?
Thank you.
I think this the minister has the authority to do this health awareness program, because it was similar to the cases of Taranto and Madigan and Victoria and Commonwealth, in which a community assistance program and an anti-discrimination program were authorized.
That raises the question of what is the legal authority on which the Minister of Health is undertaking this program? Does he have legal authority to do that? Because remember, following the principle of legality, the executive can only act if he or she is authorized by the law. What law authorizes the Minister of Health to act in this regard?
Is this section 61 of the Constitution?
Okay.
Just the broad powers of the executive?
Yes. So it can be said that according to section 61, which involves the executive to execute and maintain the Constitution and the laws of the Commonwealth, that can be authorized. It can also be said that that is in fact an implied power of the Commonwealth executive. So as pointed out earlier, it is not necessary that every single executive action or decision is requires a specific legislative authority coming from the Commonwealth Parliament. So the broad powers under section 61 of the Commonwealth Constitution, or what might be said to be implied executive powers, that would then enable the executive to be able to discharge its functions to ensure that the laws of the Commonwealth are executed, or that the executive operations of the government are fulfilled. That is the legal grant of power to the executive. This is especially crucial in the UK, because in the UK, Edward, you don't have a written constitution. So if this were to be in the UK, how can you justify an action of the Minister of Health if there is no written constitution there?
Well, they still got prerogative power. And I guess it could be implied under some other statute which gave broad powers to do this sort of thing.
That's right. So there are certain prerogative powers, and there have to be implied powers in the executive, even in the absence of the written constitution, or even in the absence of a legislative authorization or legislative enactment. The courts will assume there are implied powers in the executive, because otherwise, how else will the executive be able to fulfill its functions of ensuring that laws of the Commonwealth are executed, or of ensuring that the machineries of the government operates properly? So there have got to be implied executive powers as well, even in the absence of the mandate under Section 61, for example, of the Australian Commonwealth Constitution. So in the UK, there wouldn't have been a need. I mean, you couldn't cite Section 61 because there is no written constitution in the UK. But you could argue that on the basis of prerogative powers or on the basis of implied executive powers, the Minister of Health would have had the power or the legal power to create a health awareness program and provide a budget for it. So that's one. So we can argue that, yes, the decision is authorized. Would there be any other reasons you can cite in order for you to advise Red Manson that he shouldn't file an application for judicial review? What are the other grounds for you to say that he shouldn't be filing an application for judicial review? So what is the other requirement when it comes to an application for judicial review? Who can apply for judicial review?
So he has no standing?
Standing.
Yeah, okay. Vivian, can you explain that? What about standing?
If he is not directly affected by the decision.
Personally,
if he's not a victim of that executive decision, he doesn't have standing.
Very good. So legal standing is crucial in applications for judicial review. So if Fred cannot specifically cite any specific right or that has been violated or interfered with by the decision of the executive, as opposed to something that is experienced by the entire community, then he cannot claim a legal standing. What else? So we've cited the fact that, one, the decision is authorized because it belongs, because the executive has the power to create this program and provide a budget for it. Two, we can say that you would advise as a solicitor, against filing an application for judicial review because Red does not have legal standing. Would there be a third reason which you can cite to say that that Red shouldn't seek to apply for judicial review? Vivian, your microphone is muted.
Yes. So what I would like to say is that so long as an executive decision will only require special legal authority if it interferes with the rights of the people. Like in Lord Chief Justice Camden's statement in Entic versus Carrington, 1765. 19 ST-TR 1030.
Okay.
Yeah, so where the executive decision is not interfering with the rights of the people. Yes.
Okay.
So an executive decision will only require special legal authority if it actually interferes with the rights of the people. And here, it is not interfering with the rights of the people.
So is this also a question of justiciability?
Very good. Yeah, that's the other point, Edward. Can you explain it for us?
Well, that's just really the question of whether it's sort of within the court's remit to review that type of decision. So it might be that this is more of a sort of political decision, which isn't subject to judicial review.
Very good. So this involves the exercise of political judgment, and therefore is non-justiciable, following the case of Minister of Arts, Heritage, and Environment versus Pecco Wolson Limited. because in that case, because this involves political considerations of whether or not the health awareness program is needed by the Commonwealth, or even the budget for that matter, it involves political considerations and certainly not legal standards. And courts can only make a determination on the basis of legal and not political standards. So that's good. So there are three grounds which will be the basis for a solicitor to argue against an application for judicial review. There is no standing on the part of Red Manson. Two, this seems to be a non-justiciable question. And thirdly, the exercise of the executive power is actually authorized, either based on the prerogative power or the executive power under Section 61 of the Australian Commonwealth Constitution, or an implied power under Section 61 as well. Okay, thank you. Question 3. Can we, Vivian, can I ask you to read question 3 for us? You're muted, Vivian. Can you unmute yourself?
Sorry, sorry. Lord Chief Justice Camden's statement in Entic versus Carrington, 1765, 19 STTR 1030, is the foundational statement of the common law principle of legality. He said, by the laws of England, every invasion of private property, be it ever so minute, is a trespass. No man can set his foot upon my ground without my license, but he is liable to an action, though the damage be nothing, which is proved by every declaration in trespass, where the defendant is called upon to answer for bruising the grass and even treading upon the soil. If he admits the fact, he is bound to show, by way of justification, that some positive law has empowered or excused him. What does the principle of legality mean? Does it mean that every executive decision, in order to be lawful, must be supported by a specific legal authority that authorizes that decision?
Thank you.
Yes.
Would either Vivian or Edward wish to answer question 3?
Question 3. I said the principle of legality is a principle of common law to control government decision-making and action. It is a safeguard against government interference with common law rights and freedoms. It raises a presumption that government does not wish to interfere with common law rights and freedoms except by clear and unequivocal intent. So my answer is no, it does not mean that every executive decision, in order to be lawful, must be supported by a specific legal authority that authorizes that decision. Because this exception recognizes the power of the parliament to override common law rights and freedoms, as discussed by French CJ at the High Court in Momchilovich versus the Queen, 2011, 85 ALJR 957, and 2011 HCA 34. Where he said that the principle of legality has been applied on many occasions by this court. It is expressed as a presumption that Parliament does not intend to interfere with common law rights and freedoms, except by clear and unequivocal language for which Parliament may be accountable to the electorate. Yes.
Very good. So thanks for the Vivian. So the basic question is, when is there a specific legal authority that would be required before a particular executive action or decision can be lawfully made? In what instance or instances would there be a requirement for a specific legal authority before the executive can act or decide in a lawful manner? When do you need specific legal authority?
If it infringes someone's rights.
That's right. So when there is an infringement or an impairment of the rights or interests of citizens, for example, then in that case, you would need authorization, specific legal authorization. And so in that case, when you speak of specific legal authorization, you can particularly refer to the power which may be vested by the Commonwealth Parliament, or it could be the prerogative powers that have been recognized by the common law courts as inhering in the executive. Okay, question 4. Edward, can I ask you to read this question for us?
Yeah, sure. So can I just ask another question about the one we were just looking at?
Yes.
So were you saying that prerogative power or the board powers under Section 61, would those be specific legal authority for an action which infringes someone's rights?
Yes.
Okay. So what would be an example of something where the executive would have authority, but for the fact that it infringed someone's rights?
So what we need to remember is that when it comes, for example, to the prerogative power, there are only limited instances of when prerogative power may be said to exist. So it cannot be said that the executive power has the broad power to just do anything. So in the specific statement I made earlier, the executive authorization can be based on either an enactment coming from the Commonwealth Parliament, or it can be based on the exercise of recognized prerogative powers of the executive. Does that answer your question? Edward?
Sorry, I just unmuted myself there. Yeah, so, but are you saying that the executive can do anything as long as it doesn't infringe someone's rights?
Can do anything?
Yeah.
No, that would be too broad. It can do things which are considered to be part of the exercise of executive power without specific legislative authorization, and for as long as it does not infringe on someone's right. So, for example, the executive cannot pass laws on its own, neither can the executive undertake or exercise judicial power. So the more specific statement would be that the executive can act in fulfillment of what are recognized to be its executive powers, even in the absence of specific legislative authorization, for as long as such an executive action does not infringe or impair the rights or interests of citizens or of individuals.
Okay.
So that would be the qualification there.
Okay, thanks.
Can I ask you to read question 4 for us, Edward?
Yep. Claiming board powers under the Australian National Security Act, the Australia Security Intelligence Organisation Director General of Security ordered the arrest and detention for a period of 90 days of Jameson Ibrahim, an Australian citizen who was alleged to have recently committed atrocities in Syria. Ibrahim's solicitor filed an application with the federal court for judicial review of the legality of his continuing detention. The ASIO Director General of Security asserts that the detention is legal since it is authorised by the Australian National Security Act, which provides that the ASIO Director General of Security may cause the arrest and detention for a period not exceeding 120 days of any person who he considers on proper evaluation to be a threat to national security. Advise on the validity of the ASIO Director General of Security's argument. I thought it's authorised by the Act because they can detain for up to 120 days and they've only detained for 90 days. So, yeah, so they have authority under that Act.
Okay. So before we even look at the authorization, which I will explore further in a short while, the question really, the other basic question is, because remember we said that under the principle of legality, before the executive can act in a way that impairs the rights of citizens or of individuals, it must be based on authorization, legal authorization, which can be based on an act of parliament, or it can be based, for example, on the exercise of certain prerogative powers of the Commonwealth Executive. So it raises the basic question: is there even a right in the first place, that is infringed here? So can it be said that Ibrahim's rights have been violated by the detention, by the arrest and detention? Is there a right? So meaning, is there any recognized right on the part of a citizen not to be arrested or detained for a period of 90 days?
No, there's no issue of breach encroaching his right on his right. No.
So in other words, we as citizens don't have a right not to be arrested and detained.
We do not have. Everybody is under the law, so yeah. So even ignorance of the law is not an excuse. So yeah. So if people breach the law, they have to face the consequences. So we do not have the right not to be arrested.
So we don't have the right not to be arrested. So it's legal.
It's legal, yes.
For the police to arrest us for whatever.
If we commit crimes.
Okay.
Against the crown, any crime against the crown.
Okay. What if we are merely suspected of having committed a crime?
Well,
so the basic question really
we're
is:
presumed innocent until we're considered as innocent until proven guilty.
Okay, because all we need to remember is that there is no Bill of Rights in the Australian Commonwealth Constitution, unlike, for example, in the U.S. Constitution, which guarantees in its Bill of Rights freedom against unreasonable searches and seizures. We don't have a counterpart constitutional provision in the Australian Commonwealth Constitution. And especially in the UK or in New Zealand, where there is no written constitution, is there a recognized right against arbitrary arrest or detention?
I think, do we have habeas corpus?
Okay, so
is that right?
The basis of that judicial remedy of habeas corpus in the first place.
Sorry?
What is the basis for the judicial remedy of habeas corpus in the first place? If there is a remedy of habeas corpus, it assumes that there is a right that is actually violated by an executive action. So it brings us to the question, is there a right against unreasonable searches, seizures, or detention or arrest in the absence of a Bill of Rights in Australia? Is there a recognized right against arbitrary arrest or detention?
Yeah, is it a common law right?
Yes. So there is a common law right that is recognized, that citizens have certain liberties that may not be interfered with by a member of the executive. That presumption against the deprivation of liberty is both recognized in R versus Home Secretary, a UK case, as well as Hicks versus Rudock, as decided by the federal court, according to Justice Tamberlin. And which brings to the question about the power of habeas, the remedy of habeas corpus, whereby the courts have the power to examine the legality of arrest and detention of citizens. So, having cleared that there is a right against unreasonable arrests or detention, which means therefore that the executive cannot just arbitrarily arrest somebody, it now leads us to the other question of whether or not the ACO Director General, in causing the arrest and detention of Jameson Ibrahim for a period of 90 days, in conformity with a legislative enactment, which was the Australian National Security Act Commonwealth, can therefore be said to have validly acted. So in other words, can it be said that because of the authorization given to the ASIO Director General on the basis of the Australian National Security Act Commonwealth, which enables the Director General of Security to actually arrest and detain a person for a period not exceeding 120 days, on that basis, can it be said that it is within the power of the Director General to detain Jameson Ibrahim for a period of 90 days?
Yeah, I think so, because the Parliament has power to interfere with common law rights, and especially in this case, it's used clear and unequivocal language for which a Parliament can be accountable to the electorate.
Mm-hmm. Okay. Interesting point. Let's assume that the Commonwealth Parliament passes a law which authorizes the Director General of Security to issue shoot-on-sight orders on suspicion that somebody is suspected of having committed terrorism. And there is a law for that, passed by the Commonwealth Parliament. Would it mean, therefore, that the action of the Director General in issuing a shoot-to-kill order on the basis of a mere suspicion would be valid because there is an enabling law passed by the Parliament?
No.
Mm-hmm.
In the notes, there's a place that says that once an executive decision is going beyond, is encroaching on fundamental human rights,
Mm-hmm.
like in the case of suicide squads, is it suicide squads?
Mm-hmm.
Death squads.
Mm-hmm.
That is, so it's not acceptable. It's unauthorized.
Mm.
It's unauthorized. Yeah, if the executive should tell them to shoot on sight just anyhow. Yes.
Okay. Yeah.
And the executive officer cannot say his superior gave him that instruction.
Very good.
Because, yeah.
Very good. In fact, we can extend the factual scenario on the based on question 4 to such an extent that what if the law passed by the Commonwealth Parliament authorizes the ACU Director General to detain somebody for a period of 1 year?
Mm-hmm.
Would it mean, therefore, that the actions of the executive or the Director General of Security would be valid because it has been authorized by the Commonwealth Parliament?
But is it a question of whether the law is unconstitutional? Because
yes, can you explain that? Mm-hmm.
Well, because if the law that the decision is based on is unconstitutional,
yes,
then the executive can't rely on that as an excuse.
Exactly, that's right. So if you follow the case of A versus Hayden number 2, the High Court pointed out that it is insufficient for the executive to claim that his actions have been authorized by a statutory enactment if there has been a fundamental breach of the law. And in this particular scenario, it can be said that if a person has been, for example, has been detained for 90 days or more, it cannot be argued that that is simply to ensure that the safety or to avoid the possibility of endangering the lives of citizens. That then becomes more of a punishment. So because it is in the form of a punishment under Australia's system of government, which looks at the separation of powers, only the judiciary can exercise the power to meet punishment to individuals, not the executive or the legislature. So the court in A versus Hayden, and particularly in the case of Chu Keng Lim versus Minister of Immigration and Border Affairs, the High Court has said that it will tolerate, it will allow, it will recognize the validity of detention by the executive for a period of, let's say, 60 days on the ground that it would be meant. So that kind of executive detention is meant for the purpose of ensuring that there is no threat to the security of Australia, for example. But beyond that, it cannot be argued that that is still in the form of a security precaution, but would then be tantamount to punishment, which can only be meted by the judiciary after trial.
After trial, yes.
Okay, but in this scenario, presumably 120 days
yes.
would be acceptable. That law presumably is not unconstitutional.
That is likely to be unreasonable and unconstitutional. Because in the case of Chu Keng Lim, so there's a specific case for this, the case of Chu Keng Lim versus Minister of Immigration, the High Court has said that that kind of detention would be unreasonable because that would amount to punishment without a finding of guilt by the jury or by the judge.
Sorry, what case was that?
Chukeng Lim versus Minister of Immigration.
Was that referred to in the notes for this week?
I'm not sure. It could be.
Yeah.
It's probably in the book. I'm not sure if it was referred to in the notes, though.
Okay.
Yeah. Now, the case of Chukeng Lim versus Minister of Immigration actually makes a distinction between whether or not the one whose rights have been interfered with would be an Australian citizen as opposed to being an alien. So the High Court has said that an Australian citizen has certain rights against being arbitrarily deprived of liberty, but not aliens. And this is the reason why, if you examine the case of Vidalis versus Rudolph, especially in the case of both refugees who continue to be detained in Manus Island, that is on the basis of the exercise of executive powers. And if you will notice, a lot of these boat refugees have been there for over 2 or 3 years. And it might be said that there is a restriction of their freedom. And because there is a restriction of their freedom, it can be argued that they have been detained. But the exercise of the executive power has been seen by the court to be legal and constitutional, because aliens don't really have the right to stay in Australia. And the executive, using its prerogative powers, has the right to determine and has the power to determine who can be admitted into Australian territory. And for that purpose, it can set the rules that determines who can be admitted into Australia and those who ought to be detained for violating Australia's immigration laws. So therefore, the case of Chukeng Lim versus Minister of Immigration makes a distinction between right to liberty of citizens as opposed to aliens. So the High Court is prepared to recognize a longer period of time during which an alien is detained. Okay, so I only have 4 questions for tonight. Would there be any questions that you would like to raise, or any other points you may want to discuss? Welcome, Ernest, for joining us tonight. So at least there are now 3 of you, and 4 of us. Any questions, Vivian, Edward, or Ernest, before we end tonight's session?
Yes, I just want to ask.
Yeah.
Now that alien, the alien, is it the same as the unlawful non-citizen? No, yes.
So very good question. So the High Court actually, in the case of Chukeng Lim versus Minister of Immigration and Ethnic Affairs, said it was in relation to citizens and lawful residents. Somebody with a valid visa has the same rights as the citizen. So it is, when you speak of aliens, these are the non-legally resident aliens.
Okay.
But somebody with a lawful visa to stay in Australia has the same rights to freedom from arbitrary detention and arrest.
Okay. Yes.
Okay.
Thank you.
Okay, so thank you, Vivian. Thank you, Edward, for engaging in tonight's session. And thank you as well. I'm looking at the chat now. Thank you as well, Edward. So Edward isn't have any mic. That's fine. So thank you as well, Edward, for joining tonight's session. And so good night. And we won't be having a tutorial next week because it's going to be the midterm break. And I hope to see you again in 2 weeks' time.
Okay. Thank you.
Good night, everyone. Bye.
Good night. Bye.